I'm going with you, Josh, a couple of years ago, and I just became reacquainted a month or so ago. But in the meantime, I've been trying to find her information because I had so many people ask about this exact thing, and they needed a resource for it. And I care about you guys. I don't just care about your health insurance. If you have other problems, I want to help you find those solutions too. And so that is part of our new goal at Hanson Insurance and Club Medicare is we want to help you with anything that you need help with as much as we possibly can. And that is, we understand that we are experts, we are specialists in your health insurance. We're not experts in everything by any means, but we sure know a lot of great experts. And that's what I want to be able to introduce you to. And that's why we invited Nikki in today. So thank you so much. And is there anything else you'd like to add before we start the presentation?
Emily, I just want to say thank you for giving me the opportunity to be here. We are so fortunate to have you as a resource and all of your agents. They explain to me Medicare laws themselves because I have a lot of questions from my clients, and so I refer a lot of my clients to the Hanson Agency. We are so fortunate to have you in the community, and I really appreciate the opportunity to be here today. So thank you very much. My office, I've got two offices, one in South Austin and one in Northwest Austin, and I live in Leander. So I'm 20 minutes down the road. So thank you all again for being here. And as I go through the presentation, if you have any questions, feel free to stop me and ask and try to get all of your questions answered before I leave today. Okay. So today we're going to be talking about what is estate planning and why is it important. I think we all kind of have a basic idea of what a will is. In Texas and everywhere, and hello to our Florida people, if we pass without a will, it's called intestacy. And if that happens, then the state of Texas has written a will for you if you have not created one yourself. I was explaining before the meeting that we have two types of assets. One is probate assets, the other is non-probate assets. Non-probate assets pass outside of a court system. We don't have to go to court to probate those things. Probate assets, on the other hand, do require us to go through court. Essentially, what a probate asset is going to be are things like real property, anything that has paper to it, if you will. So if it has a title like a vehicle or a bank account that doesn't have a beneficiary, that could be a probate asset. And we might end up in court getting a judge to tell us how we can handle those assets for a deceased. Also, if you have minor children and you don't have a plan for them, then a court is going to decide for you where those minor children are going to go. And blended families, ones where they're on their second marriage and each spouse or one spouse has children from a prior marriage, this complicates things even more when we pass in intestacy. It's going to cost us a lot more than hiring an attorney and writing a customized will or a trust that reflects your wishes, because we might be in a dependent administration, which means that we're probating these assets in court and a judge has to approve everything that an administrator is doing for that estate. So this is kind of in a nutshell why we want to have a good estate plan in place. Even if we think that we don't have probate assets, we still at the very least want a will in case there are probate assets that your heirs and beneficiaries may need to probate later. So what is in an estate plan? Generally speaking, we're either dealing with a trust-based plan or a will-based plan, and I'm going to explain the differences between those two things here in a second. With either one that we choose, either the trust-based plan or the will-based plan, we're always going to have a medical power of attorney, a durable power of attorney, a directive to physicians, a declaration of guardian, and a guardian for our children. And I'm going to explain what each of those documents are in turn. So let's talk about the basic foundation. And the basic foundation is going to be, do I either choose a trust-based plan or a will-based plan for my estate? Let's talk about the differences between the two. A trust-based plan names a trustee, whereas a will-based plan names an executor. A trust-based plan does not require probate upon death as long as we keep that trust fully funded with all of our assets. And our office walks you through exactly how to do that. A will-based plan is going to require probate of that will upon death and for both parties if we're talking about spouses. Probate essentially means that we are going to court with your will, having the judge approve that will and appoint the executor that you have designated in your will. The judge then gives that person letters testamentary, which is essentially the authority to administer that will according to the provisions in it. A trust is going to remain a private vehicle between and among the parties. A will becomes public record when it is filed for probate. When we file an application to probate a will, we do have to attach the original will to it, which then becomes public record. A trust, as I mentioned earlier, requires that we fund the trust. This means that we're transferring the assets, such as your accounts, your real property, potentially your house, and I'll explain why potentially here in just a minute, into the trust, and we're titling them into the name of the trust. A will-based plan requires that we're going to regularly update documents with important changes. A trust-based plan allows for a little additional incapacity planning and incapacity management. And this is because your successor trustee is going to have the immediate authority if you are incapacitated and your spouse is incapacitated to step in and start handling the affairs of your estate. A will is only effective upon death. A trust-based plan looks more expensive up front, but because there's no probate at death, we're actually saving a pretty substantial amount of money if you're a married couple. The probate process must be followed to wind down the estate. There are several statutory steps that must be taken in order to properly probate an estate. Our office does handle all of those steps for you, but it does extend the administration of that estate. A trust-based plan always includes what I like to call a pour-over will. And what a pour-over will is essentially a will that we are going to create for you, even though you have a trust, which is going to say, I meant to put everything in my trust. If something is accidentally left out of my trust, put it in the trust, please. If that trust cannot be found, then this is what the trust says, and this is how I want my assets to go down. A trust-based plan might be easier to deal with some banks and financial institutions. If title is held in the name of the trust, we're finding that executors are having some problems dealing with banks. A lot of times they're giving some pushback, even though we have valid letters testamentary, they're extending the time that it takes to reach those accounts by a week or 2 weeks, and sometimes even longer. And we're also having similar problems with property administration. But I haven't seen any so far with trustees. Does anybody have any questions before we move on from this? Because I can't get this to go forward. Is there a... Does anyone have any questions before we move on from just the foundational trust versus will? Yes.
This is absolutely new to us. We have no proof. Most of what we are saying is talking about it.
Sure.
If we do establish a trust, will the people in the trust, like let's say my grandson, my granddaughter, whoever, do they have to pay any taxes on the amount that I put in the trust? Or how does it go?
That's a good question. The question is, how do taxes work when property is held inside a trust? For you, as the initial grantors and initial co-trustees of the trust is a pass-through entity. So for your lifetimes, you're going to continue paying your taxes exactly as you do today. There's going to be a provision inside the trust of how beneficiaries might be taxed on trust income. Generally, we tax that pro rata per beneficiary, and it's laid out according to the state statute. It's reflected directly into the trust. Now, if we have Texas does not have an estate tax, but the federal government does. And you guys have probably heard of the Big Beautiful Bill. The Big Beautiful Bill raised that estate tax to $15 million a person. So until we reach that level, we're not doing any special tax planning on that trust. That's a combined amount of 30 million a couple. So the fallback to taxing would be they're just taxed on their pro rata share of what they receive from the trust, if they're going to be taxed at all.
What would be the percentage?
It depends on what the amount is, and it depends on what the assets are. So for houses, for example, that they receive from the trust as they inherit that, they're going to get the step up in basis on that. And so depending on when they sell that property, there may not be any gains that they're making on it.
So there would be no tax on C. But the cost basis would be adjusted to when they receive it. So 10 years later, then they might pay it out.
Correct. The question was, if they sell it immediately, they're getting that step up in basis on that house, so there's not going to be a gain on it, and that is correct. If they hold on to that house and it's valued at $500,000 when they inherit it, that is their basis. And if they sell it 10 years later and it's now $1 million and they sell it, then we've got that $500,000 gain. So very good questions. Okay, so let's get back to our presentation here in a medical power of attorney. We're probably all a little familiar with what a medical power of attorney does. It allows you to designate an agent to make healthcare decisions on your behalf if your doctor certifies that you're incapable of making those decisions yourself. If you become incompetent before a medical power of attorney has been completed by you, then we may have to pursue a guardianship option through the courts, and we definitely want to avoid that. So I certainly recommend that we have a medical power of attorney in place in the event that we lose our capacity. Next is a durable power of attorney. A durable power of attorney is generally used to make plans for the care of your finances, property, and investments in the event that you can no longer handle your financial affairs yourself. A durable power of attorney does not permit the agent to make decisions about the principal's health care. We're just looking at your finances, your property, and your investments. A directive to physicians, you might have heard this called a living will before. We're making a couple of choices in this document on how do we want to receive medical treatment at some time in the future when you're unable to make wishes known on your own because of injury or illness. And when we sign these documents in my office, I go through the Texas statutory definitions of what an irreversible condition is, what a terminal condition is, and what life-sustaining treatment is, so that when we're making choices on our directive to physicians, you fully understand which choice you're making.
Can a medical PLA override a living will?
There's a medical POA over something. Say that again, no, please.
Can a medical PLA override a directive to a physician?
So the question is, does a medical power of attorney override a directive to physicians? And the answer is, in that medical power of attorney, we are specifically asking the power of attorney to abide by any advance directive you make. And I point that language out to you when we're doing the signing in my office. And so we go over those documents together. and the medical power of attorney should not override your directive to physicians. Any other questions? Okay, so next is a declaration of guardian, which is also known as a designation of guardian in advance of need. It allows a person to name a guardian of their estate and of their person in the event that they become incapacitated. These operate in a very similar way to our medical power of attorney and our durable power of attorney. Sometimes our federal agencies don't like powers of attorney and they want a guardian instead. So our office we create every option that any entity is going to want from you or your agent. And a declaration of guardian for your children, of course, that just makes sense. It names a person to care for your children if you become incapacitated or pass. In Texas, we can do this in a will, or we can do it by written declaration. We do it by written declaration, and that way we don't have to necessarily amend or re-execute your will. And we can just change the written declaration if you change your guardians. If you don't name a guardian, the courts will decide who will care for your children for you. So, common issues surrounding estate planning law and why do we want a solid estate plan? Who has been through the probate process? Has anyone here been through the probate process for anyone?
We did it with my father-in-law.
Okay. Probating a will can be a difficult and lengthy process. Some courts don't even let you do it without an attorney. Navigating the probate system can be confusing and challenging at a time when the parties are grieving, and it makes it so much harder to process what the next steps are going to be during these difficult times. Every step in executing and signing a will must be completed correctly, or the will may be invalid or more difficult to prove up. So that makes it even more complicated to get that will properly probated and moved through the court system. There are also some other requirements that come along with probating a will, like publishing a notice to creditors and filing an inventory on that estate that just take time, and it's difficult to navigate. Locating and valuing assets might also be difficult, which adds another layer of complexity to the process. Sometimes our executors have no idea what accounts our person has held or where those accounts are located or how to get access to them. Sometimes there are retirement accounts from jobs held 20 years ago that they didn't know about. And then a few years later, they find out about it and they're like, oh, now we need to get that $30,000 retirement account that we didn't know about at the time. Managing the expectations of beneficiaries can also become tough for executors. As you guys can imagine, we're already dealing with grief, we're already dealing with heavy emotions, and now we potentially have beneficiaries who think they are getting more than they're getting or who want more than they're getting, which may create problems as well. Having a probate attorney throughout this process can not only be a source of comfort, we take care of everything for you during the probate process. All we have our executors do is show up to a court hearing. I ask them about 2 minutes of questions on a witness stand. This is with a good will, and a good will means that we have a self-proving affidavit to it, we have an independent administration, and we have no bond. And then you get your letters testamentary that day, and then you can move on to administering that estate. So it makes it easier on our executors, and it also provides some practical efficiency because we're handling all those back-end requirements in our office for you.
Maybe just real quick. Did anybody understand what she just said about, she said there's 3 different things that as long as you have them, everything is pretty easy. I didn't. So I guess what I was thinking is that's why I need someone like Mickey who understands it, right? Because we don't need to understand everything if we have an expert in that department, right? So anyway,
Thank you so much, Emily. Yes. So in Texas, we can have handwritten wills. We can have wills that don't have witness signatures on them, but if we do, it becomes more difficult to prove those up during the probate process, which means we may have to call additional witnesses during the hearing to prove that it's the handwriting of the testator. We may have to call in witnesses who have seen him sign the will or her sign the will to prove that that actually happened. The wills that my office produces for you are always executed with a self-proving affidavit, which means our witnesses are swearing that they see the testator sign it. That testator is making sound decisions of their own accord, and they are over legal age to do so. We also always ask for an independent administration. I think I mentioned dependent administration earlier, where a judge is monitoring every step along the way and approving of every step along the way. We always ask for an independent administration, which allows your executor to move assets from your estate without direct supervision of the court because they have letters testamentary. And we also always ask for no bond to be posted because we want you to trust your executors, and we don't want your executors to have to put up any money to the court to prove that you're not going to run off with any of their assets. Does that help?
What if you just have it notarized?
We notarize it too. So we notarize it with our two witnesses.
Well, I'm just saying, somebody just has a handwritten will, but they have it notarized.
We're still,
I don't,
we have to call the notary and to the witness stand we have to somehow prove up that this is their handwriting and that they meant to write it and they did it of their own free will and they were competent, they were mentally competent to make the decisions at the time.
Even with a notary signature on.
Even with a notary,
Wow.
because we have to know it's that person's handwriting, right?
well, that's what a notary does.
Yeah. Some other common issues surrounding estate planning law, cohabitation. A lot of times now we have people who are not legally married who are living together. Far too often, and most lately, these are younger people, right, who pass unexpectedly and their cohabitation partner claims that they had a common law marriage and they're entitled to all of the deceased assets. So then it becomes a question of, were they common law married? And how are we going to get that question answered? Through the court system, probably, if that person had assets. I'll give you an example that in one case, grieving parents from another town wanted their child buried in their hometown. But the former cohabitation partner that the parents believed had broken up over a year ago and suddenly moved to a nearby town claimed that they had a common law marriage and threatened to have the deceased cremated unless the parent yielded to their demands, which was, give me the property of the deceased. Proper estate planning protects partners in these situations. So if we have people that are cohabitating, we definitely want to have an estate plan to cover their needs, especially if they have children from prior relationships, and especially if there could possibly be a common law marriage claim. Another issue is the importance of a directive to physicians. And I'm glad that we have some listeners from Florida here because I have an example from Florida. And you might remember the Terry Schiavo case. Does anybody remember that case that drug on for years and years and it was very public? Terry was a Florida woman who was in a persistent vegetative state before her death in 2005. At 26 years of age, 26. She suffered cardiac arrest in her home, depriving her brain of oxygen. She was in a coma for several weeks, and then she opened her eyes. She was unaware of her surroundings, though she retained a sleep-wake cycle and some instinctive movements like blinking. She was kept alive with a feeding tube in her abdomen and was transferred to a care facility where she received neurological testing, speech therapy, and physical therapy, but remained in that vegetative state for the rest of her life. Her husband sought to remove the feeding tube, and her parents fought this and wanted to remove her husband as her legal guardian. This battle played out in the courts for 15 years because Terry did not have a directive to physicians. So what is the bottom line? Estate planning is an accessible solution. It is very easy to develop an estate plan. Come to my office and we can talk through your assets and your options and design the estate plan that is best for you. There are lots of different ways that everything can go wrong, but there are some really good ways that we can make everything go right. As Richard Cushing once said, always plan ahead. It wasn't raining when Noah built the ark. So we like to put proper planning in place before we need it. Do we have any questions about anything? I know I covered a lot of broad and general things.
Yeah. All right.
What about, why do we handle some things, retirement accounts and bank accounts? Beneficiaries. So those, I guess, bypass, if you will.
Yes. Correct. So those accounts, the question is retirement accounts and bank accounts that we have named beneficiaries on. Do those bypass the probate process? And the answer is yes, they do. As long as those beneficiaries remain alive and you keep them updated, those do bypass probate and they will pass outside of your estate or your trust, unless we put them inside your trust if you have them. And then they're administered from the trust. But no need to probate those. Other questions?
Recently, I would try to find it, the document I have. I just didn't have to say it.
I can look it up for you on the deed records here when we're finished. So the question is, he went to Williamson County, filed something with the county that he had notarized, dealing with his house. So my suspicion is that it is either a transfer on death deed or a ladybird deed. Both of those deeds, and we talked about this before the meeting, both of those deeds allow a homeowner to create a beneficiary, if you will, on the house. There are a couple of ways that these two types of deeds are different. A transfer on death deed is a statutory mechanism, meaning that it is laid out in black and white in Texas law. A ladybird deed is a common law mechanism. Both of them are completely valid. They do have a couple of slight differences and they serve a few slight different purposes, but they do both allow beneficiary designations on a house. That is also a way to allow real estate to pass outside of probate. So if avoiding probate is your goal, then we've got two ways to do it. Number one, we either create beneficiary designations on everything, including all of your real property, or we create a trust.
Say
So
that again.
we've got two ways to avoid probate for your estate. Number one, we create beneficiary designations on everything you own, including your real property. So we are essentially making everything a non-probate asset. Okay. In the event that you want to proceed that way, I still highly recommend that you at least have a will, because it is possible that you're forgetting an account or two or a retirement account from years and years ago, and you will want your beneficiaries and heirs to have a way to reach those accounts without having to do a dependent administration on your estate.
If they're not listed as beneficiaries on those.
If you, will you, correct. So if, let's say, and this sometimes happens where somebody forgets that, I know it's hard to believe, but sometimes people have forgotten an account that they had when they were 20 years old or 30 years old, and that account does have money that's worth reaching in probate. So I always suggest that clients at least have a will in place. Other questions?
Need to go through recalculate percentages. on everybody.
Yes, that is correct.
Yeah.
The question is, if you want to add beneficiaries at a future point in time, and this would be true whether you're holding a trust and your assets are in a trust, or you're just using a will. If you want to add beneficiaries or change those designations, then yes, you would need to redo them and re-execute them.
And you would, how, is that just like, yeah, the beneficiary, and is that redoing the whole will, or is it just like, there gets updated?
Okay, so the question is, can you add like a codicil to a will or an addendum that updates the beneficiaries or to a trust? And the answer is you certainly can. My approach to that, however, is to re-execute because we're not really doing much different. And I would rather have a completely whole and intact document than one that is amended or have a codicil added to it, because it's the same amount of execution. We're still notarizing everything. We've still got our witnesses there. I'm still explaining to you the differences. And so from my perspective, I'd rather give you an entirely new document than risk having someone interpret the amendment differently or forgetting the codicil or forgetting the amendment somewhere. Maybe it became detached from the original will. So I'd rather just incorporate it directly into a new one and re-execute it. Yes.
Is it valid only in the USA or is the person capable of handling my affairs outside the country?
So the question is, powers of attorney, are they only valid within the United States, or can you have somebody from outside the country use them outside the country?
No, the power from US.
Okay.
But I have the property and, bank account in some other part of the world, and he or she handle that account of mine.
So it really depends on the country, and it becomes a pretty fact-specific thing. Generally, I suggest, and it depends on the country is what I'll say. So we can touch base after and talk about how that would look for you. And see what would be best in that situation.
Absolutely. Another question that I get a lot is, how can I qualify for Medicaid, maybe through a spend down program or something like that? I know you have a colleague that you work with, but I know this question is going to come up as we maybe send this video out to some of my clients. Where do you stop and he picks up?
So from my perspective, the question is, where do I stop with Medicaid planning and where does a Medicaid planning attorney step in? And I've had this conversation with several Medicaid attorneys that I've worked with in the past. And essentially, really where it matters most from my perspective, as far as how I interact with them, is when we have a trust. And how are we going to handle any real property with the trust? And so from what I've heard from Medicaid attorneys is they don't want houses deeded to a trust. We want to use a ladybird deed on the house to the trust or a transfer on death deed. But I think a ladybird deed is preferable for Medicaid planning. And a Medicaid planning attorney would essentially try to spend down your estate because you can only have a certain threshold of income and assets in order to qualify for Medicaid. So they are creating, I don't do this, but they would be creating a separate type of trust for you to hold those assets to supplement your lifestyle while you receive Medicaid benefits. So I basically do for real estate what my perspective is, don't mess up potential future Medicaid planning.
Okay. How do they reach you? If
This is my cell phone number. If you have any questions, feel free to text me. You can text me at any time. I will also hand out my business card, which has my office phone number on it and my office locations. If you guys would like to come in and have a consultation, we can sit through and talk through all of your assets and think through what the best plan for you would be. That's my email address, which you can email me there as well. But otherwise, yeah, reach out at any time if I can answer any questions for you, whether or not you choose us to do your estate planning. I'm always available to answer questions.
And you can put them in contact with someone in other states if they need that.
Correct. If for our Florida friends or anyone in a different state, I am part of a couple of networks of attorneys where we reach out to each other. So for example, I've got clients in multiple states, Washington and Idaho, and a couple of Florida. I've worked with one. So I'll reach out to these attorneys, for example, if we're doing a trust, which if you have a house in a different state, a trust is the way to go. So I'll have that attorney in that different state draft those deeds for me and file them for me, and we work together on getting those into your trust.
And then I know I'll get this question, or if I don't, people are thinking it, is how much does your consultation cost?
So for any client of Emily's, because Emily has been such an amazing resource to us and such a good referral partner and answers all of my clients' Medicare questions, I will not charge anyone a consultation fee from Emily.
Thank you very much.
Absolutely. It's my pleasure. My pleasure.
You have a question, thanks?
I've got a question.
Yes, ma'am.
How much usually is it to draw up a simple will or simple trust?
So a simple will for a single person would be $1,000, and that is going to include the medical power of attorney, durable power of attorney, directive to physicians, declaration of guardian for the person in the estate. $2,000 for a married couple. My trusts start at $4,500, I'm sorry, and that's includes one deed to the trust. And the way that I handle deeds into a trust is always through either a ladybird deed or a transfer on death deed. We take care of filing those deeds with the county clerk's office for you. All you have to do is show up. I explain everything to you page by page during a signing ceremony. We execute them, and then your plan is complete. I'll say one more thing. The trust, if you do decide to do a trust, what you get there is that pour over will. Also, the medical power of attorney, durable power of attorney, directive to physicians, declaration of guardian for your person in your estate. If there are minor children involved, it also includes the appointment of guardian for the minor children. The trust starts at $4,500. $4,500.
You can walk out of that meeting and have all of the documents you need.
Yes, we organize everything into a nice portfolio for you. Everything is organized according by tab, and it's a good sized portfolio. If you've got a trust, you're going to be leaving with your portfolio is going to be that thick. So we'll be the size, even if you don't have much. Yes, it's a lot of paperwork.
Make it easier later.
I appreciate your questions and thank you for coming today to listen to me speak. I appreciate it so much. And please reach out to me if I can answer any questions that you think of later. Thank you, guys.